Well, it is Wednesday, and I am back in the office. I came out with a blog article today regarding passcodes and passwords for electronic devices and how those issues affect your Fifth Amendment right against self-incrimination and your Fourth Amendment right against illegal search and seizure. Now, in many situations involving people charged with crimes, police often obtain search warrants to search homes, vehicles, storage lockers, practically anything. And now they're also obtaining search warrants for things like cell phones, laptops, iPads, practically any device. And obviously, nowadays, everyone has an electronic device, even kids. So these devices have created in the past constitutional issues, but as my article indicates, the Supreme Court of the United States has addressed this issue. Now, when it comes to the issue of illegal search and seizure, a court can order a search warrant to be used to search a device. There's no issue there. They can examine a device just like you can examine a home, or police can go in there and search the home, practically anywhere in the home, for evidence of contraband or evidence of a crime. Same goes with a phone or a tablet. Now, the difference is that a tablet or a phone in most situations have a passcode or a password, and it's this barrier, unlike a lock or some type of combination, which police can simply just break through. The law allows law enforcement to break down doors, to get into a storage locker or a home or a vehicle. Obviously, if they have a way of entering without damaging it, they're advised to use it. But in most situations, they have to break the barrier in some way. Now, when it comes to cell phones and smart devices, there is a difference. There's no physical barrier in the form of a lock, but there's this barrier in the form of a code which only the accused knows. Now, in that situation, the issue of self-incrimination becomes a possible issue. But what the Supreme Court has ruled is that giving up that passcode, giving up that password, is not in of itself what the law would consider testimonial. If it's not testimonial, your Fifth Amendment rights don't apply. The only exception to that would be if there's an issue with regards to your ownership of that device or control over it. For instance, if that smartphone is not just your smartphone, it's someone else's smartphone, and you share it, well, then possibly there's an argument with regards to ownership and actually who put what on there. That's a very, very common issue. Same goes with computers and laptops. Again, the issue of self-incrimination becomes real there. Now, and also with regards to self-incrimination, there has to be an argument made by defense counsel that the foregoing conclusion exception does not apply. And that's the whole basis for that article. But if you have questions about searching an electronic device in Pennsylvania, New Jersey, it is a very, very critical issue because more and more we are seeing search warrants for these devices. It's becoming a critical part of a piece of a criminal case. If you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey, 24 hours a day, 7 days a week. The website, gambonelaw.com. As always, a tremendous resource for you and your family. All my books and blogs and videos are available there in one convenient format. In addition to our podcast, where we often feature attorneys from outside the criminal defense world who speak about issues ranging from family law to personal injury to civil rights, even performance-enhancing drugs. So it's a fantastic podcast. Please check it out. But once again, if you have questions about illegal search and seizure, self-incrimination, smart devices, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey, 24 hours a day, 7 days a week. Have a great Wednesday, and I'll talk to you all very soon.